We will not be able to read every part of the judgment, but we selected relevant parts for the purposes of today. And this is in the matter of Articles 2:8, 2:10, 22C, 33, 20, and 258. And in the matter of Section 3, 4, 12, 17, and 32 of the Small Claims Court Act, Chapter 10 of the Laws of Kenya, and in the matter of Rules 5, Sub-Rule 3, and Rule 31 of the Small Claims Court 2019, in the matter of the Constitution of Kenya, Protection of Rights and Fundamental Freedoms, Practice and Procedure, Rules 2013, between James Muridhi Gathaya versus the Attorney General, the National Assembly, the Registrar of Small Claims Court, and 176 interested parties. This matter was argued before the bench, and the legal teams comprised the following: Mr. Mathai Maina, advocate for the petitioner, in petition number E008 of 2024. We also had Ms. Winnie Cherayot for the first and third respondents. We also had Ms. Ruth Nyaberi for the third respondent. For the second respondent, we had Mrs. Kimondo Gachoka, advocates for the interested parties. We also had Mrs. Morgan Msundi and company, advocates for the petitioner, in E010 2024. This is the judgment. This judgment determines the instant petition, which was consolidated with petition number E010 of 2024, vide an order made on 27th of January 2025. As at the time of consolidation, the Honorable Chief Justice had, on 13th of December 2024, empaneled this bench to hear and determine petition number E008 of 2024. Parties. The petitioner in petition E008 of 2024 is James Muridhi Gathaya, the claimant in Eldoret Small Claims Case number E1026 of 2023, James Muridhi Gathaya versus Jaban Kedode Mwanga. The petitioner in petition number E010 of 2024 is Ruben Oyamo Odoyo, the respondent in Eldoret SCC OM case number 2E247 of 2023, Jane Rose Ekisa versus Ruben Oyamo Odoyo. The first respondent is the Attorney General of the Republic of Kenya, a public office created under Article 156 of the Constitution of Kenya, and is the principal legal advisor to the government of Kenya. The second respondent is the National Assembly, one of the two chambers of parliament created pursuant to Article 95 of the Constitution of Kenya, holding, amongst other functions, legislative powers. The third respondent is the Registrar of Small Claims Court, an office created pursuant to Section 8 of the Small Claims Court Act, and is the administrative head of the Small Claims Court, which we will refer to as the court. The interested parties are parties against whom various claims had been lodged in the Small Claims Court in Eldoret, which claims are pending determination in that court. They had challenged the jurisdiction of that court to hear and determine claims for personal injuries arising out of road traffic accidents, which we refer to as RTA, but which objections were dismissed by the court, and they preferred appeals against the dismissal. Those appeals are pending before the High Court at Eldoret for determination. Petition number E008 of 2024. In petition E008 of 2024, dated 9th of April 2024, the petitioner sought the following reliefs. 1, a declaration that the Small Claims Court has jurisdiction to entertain personal injuries claimed pursuant to Section 12D of the Small Claims Court Act and Rules, and Rule 5.3 of the Small Claims Court Act and Rules 2019. B, a declaration that there is no ambiguity on Section 12D of the Small Claims Court Act and Rules 5.3 of the Small Claims Court Rules 2019. C, The interpretation, import, intention, and purpose of Section 12D of the Small Claims Court Act and Rules 5.3 of the Small Claims Court Rules 2019. D, cost and interest on the petition. And E, any other further relief. The petitioner's case. The petitioner laid down the background behind the enactment of the Small Claims Court Act, which we refer to as the Act, and its jurisdiction. He contended that the Act was designed with a specific philosophy in mind, and it was given control over its own procedures in determining claims before it, guided by principles of natural justice, which principles are distinct and separate from other procedural frameworks, including common law principles not directly or indirectly adopted by the Act. The petitioner avers that to facilitate expeditious disposal of matters, strict rules of evidence were deliberately excluded under Section 32 of the Act. He pointed out that the Act provides that when a person is claiming compensation for personal injuries, it is not mandatory to plead particulars, but rather all that a claimant is required to do is to attach the statement of claim, a medical report from a licensed medical practitioner, and any receipts for medical expenses incurred on treatment. The petitioner further avers that acting on these provisions, thousands of suits were filed seeking compensation for personal injuries sustained as a result of road traffic accidents that eventually ended up being dismissed based on challenges to the jurisdiction of the court to handle and determine personal injury claims. It is on that basis that the petitioner moved the court for their aforesaid reliefs. First and third respondents' case. The Attorney General opposed the petition via grounds of opposition dated 27th of September 2024, contending that there was no ambiguity or lack of clarity in Section 12D of the Act and Rules, which clearly outlines the jurisdiction of the Small Claims Court and includes personal injury claims, that court was a subordinate court pursuant to Article 169 sub-Article 1D of the Constitution, and as such shall be guided by the rules of evidence, doctrines of equity, common law, and any other written law, that the petition was premature and the petitioner should have waited for the preliminary objection to be determined first before lodging the petition, that there was no ruling to show that any case had been dismissed on grounds of lack of jurisdiction on the part of the court to determine personal injury claims, that the Act was specifically has specifically excluded those matters that the court has no jurisdiction on in Section 13 of the Act, and the personal injury claims is not part of that. The petitioner states that the mere fact that the small claims rules do not provide in mandatory terms that the particulars of negligence should be pleaded does not ipso facto mean that the same should not be pleaded. That the first schedule to the small claims rules from SCC1 shows how a statement of claim ought to look like, and under paragraph 4 thereof, a party is supposed to state clearly or state briefly the circumstances under which the claim arose, and those particulars can be inserted there. The second respondent's case. The second respondent opposed the petition via a replying affidavit sworn on 16th of September 2024 by Samuel Njoroge, the clerk of the National Assembly. It was deposed that the petitioner had failed to meet the mandatory requirements of precision in pleadings as established in Anarita Karimi, we've given this citation, and that he had not clearly specified the constitution, and that the petition did not provide a concise factual basis for the alleged breaches, but merely made general references to the Act and its provisions. It was further deposed that the petition failed to spell out the specific actions or omissions attributable to the National Assembly that warranted its inclusion as a respondent, that the petitioner had overlooked an available remedy under Article 119 of the Constitution, which allows for a petition to be made to Parliament to consider any matter within its authority. it was mentioned that the petition lacked merit and should be dismissed with cause. Interested parties case. The interested parties opposed the petition via a replying affidavit sworn on 23rd of September 2024 by one Wilson Waweru. He deposed that the petition was incompetent and bad in law, that a claim for personal injury resulting from a road traffic accident is based in tort and or negligence, and negligence ought to be pleaded, and the same is not provided for under the form SCC1, the attachment, the statement of claims. That a claim for personal injury resulting from RTA is a question of negligence that can only be determined by way of facts advanced through oral and documentary evidence and testimonies, which question does not qualify as a simple issue to be determined summarily without a comprehensive hearing. Further, that Rule 23 Sub-Rule 3 of the Small Claims Court Act and Rules and Section 38 of the Act restrict appeals from the Small Claim Court to points of law, yet a claim in tort or negligence, more so on RTA, requires the advancing of factual evidence. Which facts should they be misinterpreted by the adjudicator would prejudice an appellant who shall be barred from challenging such decision on appeal, hence a gross contravention and or curtailment of the right to fair hearing under Article 50 sub-Article 1 of the Constitution. The interested parties contended that courts have selectively applied the provisions of the Act, more so Section 34 subsection 1 of the Act, in favor of the claimants, whereby the respondents have been compelled to honor judgments that have been delivered out of the 60 days period stipulated under Section 34 of the Act. The interested parties maintained that in unquantified claims like negligence leading to personal injury claims, the court is unsuited to handle the same, since when a claim is unquantified, it ceases being a small claim and may morph into a claim at large. The interested parties further aver that a second medical examination is statutorily provided for under Section 3A of the Insurance Motor Vehicle Third-Party Risks Amendment Act of 2013. Under that provision, no judgment or claim is payable to any claimant unless, on the request of the insurer, such claimant subjects himself to a second medical examination by a certified medical practitioner. That this is not feasible in view of the timeline set out under Section 34 of the Act, thereby contravening Article 50 of the Constitution. Finally, the interested parties state that the strict timelines of 60 days for the claim to have been concluded curtails the respondent's chance to investigate and authenticate the documents filed by the claimant in support of a case. And further that Rules 18 sub-rule 4 of the Small Claims Court rules deny a respondent a chance to cross-examine the makers of such documents. Petition number E 010 of 2024. In this petition, dated 6th of May 2024, the petitioner sought the following reliefs: that a declaration do issue that Rule 25 sub-Rule 1 of the Small Claims Court rules, insofar as it incorporates the modes of execution in the civil procedure rules that have provisions for arrest and committal to civil jail, are ultra-vires and inconsistent with Section 37, Section 39, Section 40, and 50 sub 50 subsection 2b of the Small Claims Court Act, Cap 10A, as read with Article 94, Sub-Article 4 of the Constitution of Kenya 2010. B, that a declaration do issue that Rules 25.1 of the Small Claims Court Rules, insofar as it incorporates the application of the civil procedure rules in execution of its judgments by way of arrest and committal to civil jail, it fails to meet limitations to the right under Article 24 of the Constitution of Kenya 2010, and also does not accord a reasonable and justifiable limitation to the right to liberty guaranteed under Article 29 of the Constitution of Kenya, and it is null and void by dint of Article 2 of the Constitution of Kenya 2010. C, that a declaration do issue that the arrest and incarceration of the petitioner at the Eldoret Central Police Station was a breach of the right to liberty under Article 29 of the Constitution of Kenya 2010, coupled with an award of damages. The petition also prays for costs and interest. The petitioner laid down the facts preceding the petition. He averred that the dispute originated when one Jane Rose Ekisa instituted a claim against him in the Eldoret Small Claims Court, filed as SCCOM case number E247 of 2023, Jane Rose Ekisa versus Ruben Oyamo. It resulted in a judgment being entered in her favor for a money decree. Subsequently, she obtained a warrant of arrest in the execution of the money decree. The petitioner was then arrested by police from the Eldoret Central Police Station on the night of 28th of March 2024, detained over the civil debt and compelled to enter into an arrangement to settle the judgment in order to regain his liberty on the afternoon of 29th of March 2024. He contended that this arrest and incarceration was over a civil debt, constituted a breach of his fundamental right to liberty guaranteed under Article 29 of the Constitution, that the Act does not authorize arrest or committal to civil jail as a mode of execution, but specifies only four alternatives, that Rule 25 sub-rule 1 of the rules, which incorporates the civil procedure rules to permit civil jail, is at Travails section 37, 39, and 40, that the incorporation of civil jail by Rule 25 sub-rule 1 of the rules constitute an unreasonable and unjustifiable limitation of the right to liberty under Article 24 of the Constitution, that the Act only limits liberty for contempt of court for a maximum of 5 days. This makes the potential 6-month committal under the incorporated provisions of the civil procedure rules unconstitutional. Furthermore, that the use of civil jail violates Article 11 of the ICCPR, which prohibits incarceration merely on the ground of inability to fulfill a contractual obligation. It is on these facts and statements that the petitioner sought the aforementioned prayers. First, respondents replying affidavit in response to the petition. The first respondent opposed the petition via the replying affidavit dated 14th of October 2024, sworn by Winnie Jebet Cheroyot, the principal state counsel opposing the petition. She detailed the history of the execution proceedings and denied the petitioner's allegation that he was compelled to enter into a debt settlement agreement while at the police station. The first respondent opposed the petitioner's constitutional arguments, arguing that the right to liberty is not an unlimited constitutional right and can be limited by law, among other things, pursuant to the court orders. That the fact that the Act does not explicitly provide for committal to civil jail does not bar the court from applying any other law, including the Civil Procedure Rules and Act, to ensure that its orders are complied with when all the options are frustrated. Additionally, that the petitioner had not provided any evidence to demonstrate that the International Convention on Civil and Political Rights has been ratified in Kenya.
we have considered the pleadings, the written submissions, and oral highlights by learned counsel. The issues that fall for determination are: 1, whether this court has jurisdiction to entertain the consolidated petition; 2, whether petition number E008 of 2024 meets the threshold of a constitutional petition; and 3, whether the Small Claims Court has a jurisdiction to entertain personal injury claims under sections 12(1)(d) of the Small Claims Court Act, Cap 10A, as read with Rule 5, Sub-Rule 3 of the Small Claims Court Rules 2019. 4, whether sections 34, Section 1 and Section 38 of the Act and Rules 18 and 23(3) of the Small Claims Court Rules are null and void to the extent of their being inconsistent with Article 50, Sub-Article 1 of the Constitution of Kenya, and 5, whether Rule 25 of the Small Claims Court Rules is unconstitutional insofar as it permits execution by committal to civil jail. First issue, whether this court has jurisdiction to entertain the consolidated petition. By a preliminary objection dated the 15th of November 2024, the second respondent contended that this court has no jurisdiction to entertain the consolidated petitions because the Chief Justice had not empaneled this bench to determine petition number E010 of 2024. But this court cannot entertain matters emanating from different jurisdictions simultaneously, to wit, under Articles 165 Sub-Article 3D and Article 165 Sub-Article 3E. That by consolidating petition number E010 of 2024 and civil appeal numbers E082 to E088 of 2024 and petition number E008 of 2024, it creates procedural conflicts that cannot be reconciled in a single consolidated hearing. Finally, that the fact the second respondent was not a party in petition number E010 of 2024 and the civil appeal numbers E082 to E088 of 2024, and therefore there was misjoinder of parties. Ms. Nyaberi, learned counsel for the second respondent, submitted that since the Chief Justice had not assigned petition number E010 of 2024 to the bench had no jurisdiction to entertain it. That in that petition, the petitioners sought constitutional interpretation under this court's original jurisdiction to hear and determine questions of interpretation of the Constitution under Article 165(3)(d). That under Article 165(3)(e), this court exercises its appellate jurisdiction and its determination on matters emanating from the Small Claims Court is final. That if the matter proceeded as consolidated, the matters to be determined in this court's appellate jurisdiction will be subject to the appeal to the Court of Appeal and Supreme Court when its decision on the interpretation of the Constitution is appealed against. We have carefully considered the record. We agree with Ms. Nyaberi that as at the date of the preliminary objection, the Honorable the Chief Justice had not yet empaneled this bench to hear petition number E010 of 2024. However, on the 13th of December 2024, the Chief Justice empaneled this bench to hear and determine the said petition. The order for consolidation of petition numbers E008 of 2024 and E010 of 2024 was subsequently made on the 27th of January 2025, which was after the empanelment. Accordingly, that part of the objection became obtuse. The other ground is that this court cannot exercise two distinct jurisdictions simultaneously, viz., constitutional interpretation under Article 165 Sub-Article 3D of the Constitution and the appellate jurisdiction of Small Claims Court matters under Article 165 Sub-Article 3E. That is so because while a decision under Article 165 Sub-Article 3D of the Constitution is appealable all the way to the Supreme Court, a decision under Article 165 Sub-Article 3E, as read with Section 38 of the Small Claims Court Act, is final. We agree with Ms. Nyaberi that the two jurisdictions cannot be exercised simultaneously on the grounds she advanced. However, that is not the case here. From the record, this court did not consolidate the two petitions E008 of 2024 and E010 of 2024 with civil appeal numbers E082 to E088 of 2024 as contended. Indeed, the said appeals were never referred to this bench by the Chief Justice for any determination. There is no order on record to that effect. The appeals may have been consolidated at their station of filing, but they were never referred to us or assigned to this bench by the Chief Justice for determination. Our understanding is that when the said appeals were filed, they triggered the filing of constitutional petition number E008 of 2024, dated the 4th of April 2024, while civil appeal number 103 of 2025 triggered the filing of 103 of 2024, triggered the filing of constitutional petition number E010 of 2024. The fact that the records of the said appeals were placed before us did not mean that they were so placed for our determination. In our view, they were only produced as exhibits or evidence of the prejudice that the petitioners alleged they stood to suffer if the sections of the act they sought to be interpreted were not so interpreted in their favor. The said appeals were basically placed before us as evidence of what had transpired prior to the institution of the petitions, but not for our determination. Accordingly, there is no appeal before us invoking this court's appellate jurisdiction under Article 165, Subarticle 3E of the Constitution. This court is only exercising its jurisdiction under Article 165, 3D of the Constitution. Accordingly, the preliminary objection by the second respondent, dated the 15th of November 2024, is without merit and is hereby dismissed. Second issue, whether petition number E008 of 2024 meets the threshold of a constitutional petition. It was contended by the second respondent that the said petition did not satisfy the requirements of precision pleading in constitutional violations as initiated in the case of Anarita Karemi Njeru versus the Republic. That the petitioner did not clearly specify the constitutional provisions that had been violated, and that the factual basis of the breaches by the second respondent had not been specifically pleaded. In the aforesaid Anarita Karemi case, it was held that, quote, if a person is seeking a redress from the High Court on a matter which involves a reference to the Constitution, it is important, if only to ensure that justice is done to his case, that he should set out with a reasonable degree of precision that of which he complains, the provisions said to be infringed, and the manner in which they are alleged to be infringed, quote. In Mungu Matemu versus Trusted Society of Human Rights Alliance, 2014, the Court of Appeal reinforced and re-emphasized the said position as follows, quote, the principle in Anarita Karemi Njeru underscored the importance of defining dispute to be decided by the court. Procedure is also a handmaiden of justice, of just determination of cases. Cases cannot be dealt with justly unless the parties and the court know the issues in controversy. Pleadings assist in that regard and are a tenet of substantive justice, as they give fair notice to the other party. The principle in Anarita Karemi Njeru that established the rule that requires a reasonable precision in framing of issues in constitutional petitions is an extension of this principle. Close the quote. And then in Harris Mboro versus Inspector General of Police, the court held, quote, one of the cardinal principles in constitutional litigation is that a party who claims that a right or fundamental freedom has been violated, is being violated or is threatened, must plead with accuracy and precision, demonstrating the right violated or infringed, the article of the Constitution violated, and the jurisdictional basis for it. That is, it is now an established principle of law that anyone who wishes the court to grant a relief for a violation of a right or fundamental freedom must plead in a precise manner the constitutional provisions said to have been violated or infringed, the manner of infringement, and the jurisdictional basis for it, quote, quote. Simply put, precision pleading is a mandatory requirement in constitutional petition. A petitioner should clearly specify the right or fundamental freedom that has been violated or infringed or threatened with infringement. He must state how the violation or infringement occurred, the specific articles of the Constitution that are alleged to have been infringed or violated, and the jurisdictional basis for the court's exercise of its jurisdiction. This will not only enable a respondent to know the case he is facing, to be able to make an appropriate response, but will also assist the court to understand the case before it, to be able to give the appropriate remedy or relief. From the outset, it would seem that the petitioner did not properly draw his petition as required. All he did was to cite the various articles of the Constitution, to it, Articles 2, 10, 22, 23, 48, 50 Subarticle 1, 95 Subarticle 3, 109, 165, 159, and 258 of the Constitution, without specifying how they had been infringed or how they are related to the reliefs he was seeking. In our view, the most pertinent articles would be Article 10 on the rule of law, Article 22, Article 1, enforcement of Bill of Rights and public interest, Article 48, which is for access of justice, Article 51, fair hearing, Article 95.3, constitutional authority of the National Assembly, and therefore jurisdictional basis, and Article 159, justice should not be delayed. The petitioner failed to specifically set out the respective rights violated and how they relate to the reliefs he sought. All he did was to cite the articles and allege how the right to access to justice was threatened to be violated by the likelihood of the Small Claims Court being held not to have jurisdiction on claims for personal injuries arising out of RTA. If the petition had sought constitutional reliefs, this would have been a proper petition for striking out. However, the petition only sought the interpretation of Section 12, Section 1 of the Small Claims Court Act, vis-a-vis the right to access to justice and the national principle of the rule of law under Articles 48 and 10 of the Constitution, respectively. The respondents and the interested parties understood the case they faced and responded appropriately. Further, this court was able to disarm the petitioner's case and will be able to give the appropriate relief. For the said reasons, we are inclined to sustain the petition, albeit to declare ourselves on the statutory provisions sought to be interpreted. Accordingly, that objection is overruled. Third and fourth issues. Whether the Small Claims Court has jurisdiction to entertain personal injury claims under Section 12(1)(d) of the Small Claims Act, Small Claims Court Act, as read with Rule 5.3 of the Small Claims Court Rules 2019, and whether Sections 34(1) and 38 of the Act and Rules 18 and 23.3 of the rules are null and void to the extent of their being inconsistent with Article 50, Article 1 of the Constitution of Kenya. We have decided to combine, consider, and determine issue numbers 3 and 4 together because they are related. This is so because the issue of the alleged unconstitutionality of Sections 34(1) and 38 of the Act and Rules 18 and 23.3 of the rules was raised on the face of the Small Claims Court entertaining personal injury claims arising out of RTA. It was contended by the interested parties that in view of the nature of claims for personal injury claims arising out of RTA, the alleged provisions of the Act breached the right to fair hearing under Article 50, Article 1 of the Constitution. It is for that reason that we decided to consider the two issues together. It was contended that the petitioner's suit in petition number E008 of 2024 had been objected to on the basis that the Small Claims Court lacks jurisdiction to entertain personal injury claims in RTA. That due to the holding in Ogwari versus Harsi Civil Appeal number 223 of 2022, the petitioner's case, amongst others, may be dismissed for alleged want of jurisdiction. That this court should declare that the Small Claims Court has jurisdiction under Section 12(1)(d) of the Act and Rule 5.3 of the rules, so as to save those suits. The respondents agreed with the petitioner that court has jurisdiction under the cited provisions. However, the interested parties were of a contrary opinion. They opposed the petitions and raised issues of the unconstitutionality of Rule 23.3 of the rules on admission of evidence without calling the makers, Section 38 of the Act, restriction of appeals to purely points of law, Section 34(1) of the Act, finalization of matters within 60 days of filing, as being violation of Article 50, Article 1 of the Constitution on the right to fair hearing. Jurisdiction is everything, and it flows from the Constitution or statute. The Court of Appeal in the Lillian S. case held that jurisdiction is everything. Without it, a court has no power to make one more step. Where a court has no jurisdiction, there would be no basis for a continuation of proceedings pending other evidence. A court of law down tools in respect of the matter before it the moment it holds the opinion that it is without jurisdiction. where a court takes it upon itself to exercise jurisdiction which it does not possess, its decision amounts to nothing. Jurisdiction must be acquired before judgment is given. Quote. The court has been called upon to interpret certain provisions of the Act vis-a-vis Article 50, Article 1 of the Constitution. In Alcoholic Beverages Association of Kenya versus Kenya Film and Classification Board judgment, the Court of Appeal observed as follows, quote, the Australian case of Amalgamated Society of Engineers versus Adelaide Steamship Company Limited, as quoted in the County Government of Nyeri and another versus Cecilia Wangeshi Ndungu 2015 KLR, set out the fundamental rule of interpretation as being that a statute is to be expounded according to the intent of Parliament that made it. And that intention is to be found by an examination of the language used in the statute as a whole. What does the language mean? In its ordinary and natural sense, it is our duty to obey that meaning. It is a truth universally acknowledged that the English language, both legal and general, has words which may have more than one meaning. And on account of this, many common law jurisdictions have applied 3 approaches to statutory interpretation. These are the literal rule, having the ordinary plain meaning, the golden rule, which looks at the intention of the legislature and to avoid absurdity, and the mischief rule, what remedy did the legislation intend to cure? We concur with the first respondent that the first port of call is to examine the preamble of the statute. From the foregoing, it is clear that the first point of call is to look at the act itself in order to determine the meaning sought. The question put by the petitioner in E008 of 2024 is a determination as to whether the Small Claims Court has jurisdiction to determine claims for personal injury claims. The Small Claims Court Act, Cap 10, was enacted by the legislature in 2016. It was assented to on the 1st of April 2016 and commenced on the 21st of April 2016. Its preamble provides that it is an act of Parliament to establish Small Claims Court to provide for the jurisdiction and procedures of the court and for connected purposes. The jurisdiction of that court is provided for in Section 12, subsection 1 of the Act, which provides, quote, subject to this Act, the rules and any other law, the court has jurisdiction to determine any civil claim relating to A, a contract for sale and supply of goods or services, B, a contract to money held and received, C, liability in tort in respect of loss or damage caused to any property or for the delivery or recovery of movable property, D, compensation for personal injuries, and E, set off and counterclaim under any act, quote. Further, Rule 5.3 of the Small Claims Court Rules 2019 provides, quote, a person claiming compensation for personal injuries pursuant to Section 12(1)(d) of the Act shall attach to the statement of claim A, a medical report from a licensed medical practitioner, and B, any receipts in respect of medical expenses incurred on treatment, quote. A cursory plain reading of the above provisions would show that the Small Claims Court is given jurisdiction to entertain claims for personal injuries. However, as held in the case of the County Government of Nyeri and another versus Cecilia Wangeshi Ndungu, the fundamental rule of interpretation is that a statute is to be expounded according to the intent of Parliament that made it. That intention is to be found by an examination of the language used in the statute as a whole and not selectively. Further, as was held by the Court of Appeal in the Alcoholic Beverages Association of Kenya case, there are 3 approaches to interpretation of statutes. These are the literal rule, having the ordinary plain meaning, the golden rule, which looks at the intention of the legislature to avoid absurdity, and the mischief rule, what mischief the legislation intended to cure. The fundamental grievance, insofar as the substantial part of the jurisdiction exercised by the Small Claims Court in personal injury claims arising out of RPA, is its adjudicatory process. The content of the right to a fair hearing, implicit in Article 50 of the Constitution and in pari materia to civil law, includes notice, pre-trial discovery, fact-finding based only on evidence presented, a duty to consider the case properly by the trial court, application of the concept in which the trial of facts hears all the evidence from both the claimant and the respondent, so as to make a determination on the merits. The notice in this sense will include the requirement of pleading setting out the elements of negligence and breach of duty of care, by the respondent, occasioning loss and damage, which gives rise to a cause of action. The pleading in this sense is to ensure the respondent knows something about the case to be met, which includes the notice to persons who will be directly affected by the judgment of the court. Discovery involves access to most of the relevant documents or real evidence relevant to a case based on the tort of negligence in accident claims. This notice must be issued in advance in the form of a demand notice to avoid surprise, or what we would refer to as microwave justice. The constitutional imperative of notice and to challenge evidence adduced by a claimant requires that a respondent be given an opportunity to examine the opposite party under oath on the depositions used in various levels at the trial. This cannot be limited by a statute. The Small Claims Court Act, in its procedural law, appears to be limiting the holistic approach of the Evidence Act, Cap 80 of the laws of Kenya, which is in tandem with the Article 50 of the Constitution. A further principle of fairness is that a person or a litigant to a dispute should not have his or her rights affected directly unless there is inclusivity and participation within the due process clauses as fair trial rights. We have had an opportunity to revisit the Hansard, the precursor to the enactment of the Small Claims Court Act. It was unanimous during the debate by the second respondent that the court was designed to provide an accessible, fast and cost-effective method of resolving civil disputes involving small amounts of money, often without the need for a lawyer. The procedures contemplated and adopted by the second respondent were generally more informal as contradistinguished with the jurisdiction conferred in the magistrates' courts. The jurisdiction of the court, therefore, primarily was meant to handle civil claims or actions for the payment of money which was capped at below 1 million. The jurisdiction of personal injury claims, which by dint of insurance contracts on policies secured between the insurer and the insured, makes them complex, which require the entire regulatory framework and applicable statutes like the Cap 405 of the laws of Kenya, not to be rendered moribund. The letter and spirit of the Small Claims Court is the real people's court, meant to provide an informal and complicated proceedings to resolve small disputes that do not involve large sums of money to warrant the expense and legal threshold of formal litigation before the magistrates' courts. We see that court as a vehicle for social change and the case for equitable relief. Therefore, being a people's court where personal small value disputes are quickly and informally resolved without the need for legal representation mitigates the cancer of backlog in a litigious society like Kenya, where every dispute is a threat to another CU in court. A claim for compensation for personal injuries in RPA cannot qualify as a small and simple claim. The law of tort of negligence in Kenya follows the common law principles that require proof of duty, breach, causation, and damages awardable for the loss suffered by a claimant. The litigation on this branch of law focuses and addresses foreseeability, contributory negligence, occupiers liability, and doctrines like res ipsa loquitur. For example, on negligence, the threshold issue must be within the fulcrum of known principles. Lord Hoffman, writing in the Law Quarterly Review 2005 LQR, stated as follows. First, first, it is usually a condition of liability that not only should one have done or been responsible for some act which the law regards as wrongful, but that there should be a prescribed causal connection between that act and damage or injury for which one is held liable. There may be other conditions as well, such as that the harm should have been foreseeable, but some prescribed causal connection is usually required. Secondly, the question of what should count as a sufficient causal connection is a question of law. The claimant must, as a matter of law, establish a causal connection, commonly known as the but-for test, between the injury suffered and the conduct of the defendant. The but-for test recognizes that compensation for negligent conduct should only be made where a substantial connection between the injury and the defendant's conduct is present. It ensures that a defendant will not be held liable for the plaintiff's injuries where they may very well be due to factors unconnected to the defendant and not the fault of anyone. The material contribution test, on the other hand, is to be only applied in special circumstances where two requirements are met. These are, one, where it is impossible due to factors outside the plaintiff's control for the plaintiff to prove that the defendant's negligence caused the plaintiff's injury using the but-for test, and 2, where it is clear that the defendant breached a duty of care owed to the plaintiff, exposing the plaintiff to an unreasonable risk of injury, and the plaintiff suffered an injury, quote. In the present case, the provision that sets out the jurisdiction of the Small Claims Court is Section 12(1) of the Act. That section states that the jurisdiction given to that court is subject to the Act, the rules, and any other law. This, in our view, means that if the Act does not expressly allow or provide for any act, the provisions of any other law shall be applicable. The Act will not be interpreted or applied to cause absurdity. The basis for the challenge of the jurisdiction of the court was that in Ogwari versus Hersey case, the court had found that due to the nature of a claim for personal injuries in RTA, those claims were not suitable for the Small Claims Court. However, there were subsequent decisions by the High Court which held that the Small Claims Court has jurisdiction to entertain such cases. This include the cases of Gichovi versus Kilem, 2024, Ochieng versus Mushila, 2025, and Irungu versus Karanja, 2024. It is right that when the language used in a statute is plain and unambiguous, it is not permissible for the court to go outside the four corners of the provision to seek the meaning thereof. In the present case, the jurisdiction as provided in Section 12 of the Act includes compensation for personal injuries. The Act does not specify the types of personal injuries that are justiciable under that provision. It would therefore be expected that all forms of personal injuries, howsoever arising, are to be covered by that provision. The question then is, did the legislature intend that the Small Claims Court entertain all manner of claims for personal injury, including those arising out of RTA? Is there a difference between the various personal injury claims in existence? It is not clear from the Act itself whether the legislature intended all kinds of personal injury claims to be covered. Personal injury claims may arise out of physical injury, out of assault, road traffic accident, or even psychological trauma. A claim arising out of RTA is based on the tort of negligence that must be proved. For this reason, it cannot be said that Section 12(1)(d) of the Act is so clear and unambiguous as to the nature of the claims for personal injuries contemplated. One needs to read the entire Act in order to discern the intention of the legislature when it created that code and the jurisdiction it intended to assign to it. We have already adverted to what was debated in the chambers of the second respondent during the enactment of the Act. The court was meant to deal with unresolved disputes for limited amounts in a faster, more affordable, and less complex processes than the traditional courts. That is why the Act provides for simplified and affordable processes with the monetary limits of 1 million and below. That court was designed to be a commercial court geared towards helping the small and medium businesses to spur economic activities devoid of long, torturous, litigious road known in the traditional courts. In other jurisdictions, small claims courts deal with small claims and or disputes that can be dealt with and determined summarily. For example, in Zambia, the small claims courts are presided over by experienced advocates who have the title of state counsel. They deal with cases and determine them on the same day the hearing commences and in a summary manner. In our case, in order to achieve the goal meant for that court, the legislature introduced certain provisions in the Act in order to achieve its intention. Some of these are personal representation, representation by a non-legal practitioner under Section 20 of the Act, filing of claims by way of simple forms, Section 23 of the Act, exclusion of strict rules of evidence, Section 32 of the Act, admission of evidence without calling the makers, Rule 23(3) of the rules, restriction of levels of appeal and to purely points of law, Section 38, and the strict timelines with the matters being finalized within 60 days, Section 34(1) of the Act. The interested parties invited this court to declare some of the aforesaid provisions as infringing the right to fair hearing under Article 50, Sub-Article 1 of the Constitution of Kenya. That provision provides, quote, Every person has the right to have any dispute that can be resolved by the application of law in a fair and public hearing before a court or another independent and impartial tribunal or body. Quote, quote. The above provision enunciates the right to fair hearing. That is a right that cannot be derogated. That right connotes the giving a party an opportunity of being heard, and that opportunity should be reasonable. Reasonableness will encompass the giving of a party an opportunity to challenge the adversary's case. Such challenge includes testing the evidence adduced in support of the adversary's case, especially when it is an opinion such as that of an expert. The notion of procedural fairness is founded in Articles 10 and 50 of the Constitution. These articles are not without undue interpretative strain consonant with subordinate legislation, like the one in discussion by the petitioners and as adverted to by the interested parties. The concept of procedural fairness has come to occupy the central place in controlling decision-making processes by judges, magistrates, and chairs of tribunals as duly constituted under Article 51 of the Constitution and the enabling statutes. In our legal system, procedural fairness is based on natural justice. It is a well-defined concept which comprises entirely a fundamental rule of fair procedure that a person must always be fairly heard. The need to secure fairness would highly increase in intensity when it comes to the resolution of disputes which involves complexity of issues and the interest of individuals directly affected cannot be driven out of the judgment seat without observance of the tenets of fair trial rights. In the present case, the issue is whether the Act encompasses or derogates this right to fair trial in claims for personal injuries arising out of RTA. Our reading of the Act reveals that it was not contemplated that in the claims before that court, particulars of negligence be pleaded and that the same be proved. This is so because the claims in that court are by way of simple forms, which sets out what is to be pleaded. See Section 23 of the Act. A claim for personal injuries out of RTA cannot be pleaded without particulars of negligence, which are to be proved at the trial. The architecture of the Act did not contemplate that fact. It was argued that paragraph 4 from SCC 1 permits the pleading of the particulars of negligence. We are afraid that that is not expressly provided for in that paragraph, and that the same cannot be read into it. In any event, those particulars, if and when pleaded, they must be proved. Negligence, as defined in Black's Law Dictionary, is, quote, quote, the failure to exercise the standard of care that a reasonably prudent person would have exercised in a similar situation. The elements necessary to recover for negligence are: 1, the existence of a duty on the part of the defendant to protect the plaintiff from injury complained of, and 2, an injury to the plaintiff from the defendant's failure. In negligence, therefore, a claimant ought to establish that the respondent owed him a duty of care, that there was a breach of that duty, and that as a result of that breach, the claimant suffered damages. In the celebrated case of Danagu versus Stevenson, the principles necessary for a claim for negligence were enunciated as, quote, quote, the law takes no cognizance of carelessness in the abstract. It concerns itself with carelessness only where there is a duty of care, and where failure in that duty has caused damage. In such circumstances, carelessness assumes the legal quality of negligence and entails the consequences in law of negligence. The cardinal principle of liability is that the party complained of should owe to the party complaining a duty to take care, and that the party complaining should be able to prove that he has suffered damage in breach of that duty, quote, quote. In Magna Patel versus TA 2014, the need to plead and prove negligence was emphasized. The court held, quote, quote, I also take note of the fact that in our legal system, there is no liability without fault. In this regard, see Kiema Mutuku versus Kenya Cargo Handling, 1991 PKLR, where the Court of Appeal held, quote, quote, there is as yet no liability without fault in the legal system in Kenya. And a plaintiff must prove some negligence against the defendant where the claim is based on negligence. The fault has to be pleaded and proved by evidence at the hearing, quote, quote. We are therefore of the view that the provisions of sections 20, 23, 32, and 38 of the Act and rules 23.3 of the rules were deliberately introduced in the Act not to restrict the right to fair trial, but to facilitate the smooth and informal processes of the nature of cases contemplated for that court. From our observations above, claims for personal injuries in RTA were not contemplated to be for that court. Another fact is that claims for personal injuries arising out of the RTA are governed inter alia by the Insurance Motor Vehicle Third Party Risks Act 2013. It is provided therein, inter alia, under section 3A, quote, quote, no judgment or claim shall be payable by an insurer unless the claimant had before determination of liability, at the request of the insurer, subjected themselves to medical examination by a certified medical practitioner. 3B, an insurer shall have a right to obtain or verify information from the institution which issued the documents intended to be used to prove the claim, and this right shall be enforceable before judgment is passed, provided that such verification shall be done within a month, quote, quote. When the foregoing rendition on the thought of negligence and the provisions of the Insurance Motor Vehicle Third Party Risks Act 2013 is juxtaposed with the impugned provisions of the Small Claims Act, it becomes crystal clear that the claims for personal injuries in RTA were never contemplated for the Small Claims Code. The jurisdiction set out in section 12(1) of the Act is subject to any other act or any other law. In this case, the jurisdiction to determine claims for personal claims under section 12(1)(d) will be subject to the provisions of the Insurance Motor Vehicle Third Party Risks Act. That being the case, as shall appear hereunder, several of the provisions of the Act which were introduced to operationalize the Small Claims Code would fall foul of the latter Act, that is the Insurance Motor Vehicle Third Party Risks Act. Section 32 of the Act excludes the application of the rules of evidence in that code. Section 34 provides that suits in that code shall be determined within 60 days from the date of filing the claim. This timeline goes contrary to sections 3A and 3B of the Insurance Motor Vehicle Third Party Risks Act that permits the insurer to refer a claimant for a second medical report and 60 days for verification of information presented by 30 days for verification of information presented by a claimant. Further, Rule 23 of the rules permits the production of expert opinions without calling the makers thereof. From the foregoing, subjecting the claims for personal injury in RTA to the Small Claims Code would limit the rights of the insurers under Section 3A and 3B of the Insurance Motor Vehicle Third Party Risks Act, and therefore fall foul of Article 50 of the Constitution. If it was the intention of Parliament or the legislature to limit that right, it would have used words such as, quote, quote, notwithstanding the provisions of any other law, quote, quote, in Section 12(1) of the Act. That would have expressly excluded Sections 3A and 3B of the Insurance Motor Vehicle Third Party Risks Act. In our view, the legislature did not do so deliberately because it never intended such complicated claims such as those for personal injuries arising out of RTA to be part of the jurisdiction of the Small Claims Code. Further, it will be double standards and therefore discriminative to allow claimants with claims for personal injuries out of RTA for less than 1 million to be treated differently from those with similar claims for more than 1 million shillings. In any event, if it was the intention of the legislature to limit the rights of the insurers under Sections 3A and 3B of the Insurance Motor Vehicle Third Party Risks Act, nothing would have been easier than to state so, as it did on the application of the rules of evidence under the Evidence Act. Indeed, in Gwari v. Hals, the court was alive to this fact when it held, quote, however, for injury claims, there is need to have more thorough review of medical evidence, including having a second medical examination. To be able to fully and properly defend such claims, 60 days will definitely be sufficient. We find that the provisions of Section 23, 32, 34, and 38 of the Act, and Rule 23(3) of the rules are not in violation of Article 51. They were deliberately introduced in the Act by the legislature in order to operationalize the Act and achieve the letter and spirit of the Act. To the contrary, it is the nature of the claims for compensation for personal injuries in RTA that were never contemplated in Section 12(1)(d) of the Act. In this regard, we find and hold that claims for compensation for injuries arising out of RTA were not contemplated to be part of the matters to be entertained by the Small Claims Code under Section 12(1)(d) of the Act. Their inclusion as part of that section would introduce the doctrine of strict liability on such claims. If the legislature intended to introduce strict liability on personal claims in RTA, nothing would have been easier than to so expressly state. Having come to the foregoing conclusion, we are in doubt if there would be jurisdiction for claims for liability in torts in respect of loss or damage caused to motor vehicles arising out of RTA as contained in Section 12(1)(c) of the Act. Since, however, that issue was not raised before us and the parties did not have an opportunity to address us on the same, we refrain from making any determination thereof. Accordingly, we find and hold that the Small Claims Code has no jurisdiction to entertain claims for compensation for personal injuries arising out of road traffic accidents under Section 12(1)(d) of the Act.
In this continuum, we answer the question whether Rule 25(1) of the Small Claims Code is that provides Section 37, 39, and 40 of the Small Claims Code Act, the Parent Act, as read together with Article 94, subsection 6 of the Constitution. Section 37 of the Act provides enforcement of orders to pay money. Every order made by the court requiring a party to pay money that shall be enforced in accordance with the provisions of this Act. Where an application is made to the court for the issue of any process to enforce an order requiring a party to pay money for another as an alternative to compliance with a work order, that court shall give notice of application to the party against whom enforcement is sought. Subsection 3, if the party referred to in subsection 2 does not file in the court within the period prescribed for so doing a notice of objection on the prescribed form, the order may, after the expiry of that period, be enforced pursuant to subsection 1. The notice referred to in subsection 3 may only be given on the ground that it is the belief of the party that the order of this court has been fully complied with, and that the party therefore disputes the entitlement of the application to enforce it. 5. If the party against whom enforcement is sought files the notice referred in the subsection within the prescribed period, the matter by a person who seeks to enforce an order pursuant to subsection 1, but any fee which would otherwise be payable shall be included in and be considered as part of the award of the court and shall be recoverable from the opposite party for the credit of the consolidated fund. Section 39 of the Act provides that the procedure for execution, where a judgment debtor fails to pay to the decree order any sum specified in a decree order, the court may, where the judgment debtor's movable property is insufficient to satisfy the decree, order execution by attachment and the sale of the judgment debtor's immovable property. B. Order the attachment of the salary of the judgment debtor. C. Suspend the execution of the warrant and order either wholly or any part on which conditions are the security or otherwise as the court may determine. Section 40. Manner of execution, where the judgment debtor fails to discharge the decree in all or any part within the time or in terms, if any, specified in an order of the court may order execution to issue against the judgment debtor's immovable property or an other of his or her assets. The power to enact the Small Claims Court rules is vested in the Chief Justice. Under Section 50 of the Small Claims Court Act, the same provides power to make rules. The Chief Justice may make rules of practice and procedure for the better functioning of the court. For the purpose of Article 94, subsection 6 of the Constitution, the purpose and objective of the delegation under this section is to enable the Chief Justice to make rules to provide for the better carrying out the effect, the provisions of this Act. The authority of the Chief Justice to make rules under this Act shall be limited to bringing into effect the provisions of this Act and the fulfillment of the objectives specified under this section. The principles and standards to the rules made under this section are those set out in the interpretation and the general provisions of Act Cap 2 and the statutory instruments Act Cap 2A. This section grants the power to make rules for the better carrying into effect of the provisions of this Act. Subsidiary legislation is ultra-vires if it attempts to amend, contradict, or extend the scope of the parent Act. Section 37 of the Small Claims Court Act explicitly governs the execution of decrees and orders under the Act, stating in mandatory terms that the execution shall be in accordance with the provisions of this Act. On the other hand, Rule 25(1) of the rules provide that a decree or order of the court shall be executed in accordance with the provisions of the Civil Procedure Act and the rules made thereunder relating to execution. We have deliberately set out the above provision extenso due to the significance and the fundamental of this particular judgment. The execution provisions of the Act, in order to juxtapose the same with the imbued rule, in the three execution sections, that is 37, 39, and 40, the Act specified both the procedure and the manner of execution of the court's orders. We believe that this was deliberate on the part of the legislature. This was so considering that this was a special statute, creating a special court with special jurisdictions. It is clear that the Act did not expressly provide for arrest and committal to civil jail as a mode of execution. Arrest and committal to civil jail is not a mode of execution provided for under Section 37, subsection 1 of the Act. That was incorporated by Rule 25, subsection 5(1) by way of a reference. We are alive with the fact that the Act has not specifically expressed an intention to limit the right to liberty by providing for arrest and committal to civil jail as a mode of execution of a manner decree. The only limitation, in our view, is as submitted by the petitioner, by the petitioner in cases of the offense of contempt of court under Section 47, subsection 2 and 3 of the Act. In its detailed provision, it is proved that primary objective of the court is compensation through recovery, flexibility, and settlement, not the immediate enforcement of a penal measure. The authority donated by Section 50 of the Act was limited to bringing into effect the provisions of the Act. In our considered view, Rule 25 of the rules, incorporating by reference the civil procedure rules, it went beyond the delegated authority to make rules as conferred by Section 50, subsection 2 and B of the Act, as read with Article 94, subsection 6 of the Constitution of Kenya. We are in agreement with the principle enunciated in the case of Katiba Institute and another versus the AG, and also the Independent Policing and Oversight Authority, and the three others, which is a constitutional petition 379 of 2017, that there can be no legislation by reference. Legislation must and should be expressed and clear. This is clearly buttressed by the provisions of Article 94, subsection 6 of the Constitution, which states an act of parliament or legislation of a country that confers on any state organ, state officer, or person the authority to make provision having the force of law in Kenya, as contemplated in Clause 5, shall expressly specify the purpose and objectives for which that authority is conferred, the limits of the authority, the nature and the scope of the law that may be made, and the principles and the standards applicable to the law made under that particular authority. We are alive with the fact that the provision of the civil procedure rules for arrest and committal for civil debt is not per se unconstitutional or illegal. This is not a mere leap. It is not a mere leap to committal. The Civil Procedure Act imports the full spectrum of non-punitive remedies under Section 38 of the Civil Procedure Act, including attachment of property and garnishment. The ultimate measure of arrest and detention, as provided under the Civil Procedure Act, is subject to the stringent constitutional and statutory test of willful default and not mere inability to pay. The strict condition precedent is set out in Section 38 of the Civil Procedure Act, which prohibits committal unless the court is satisfied, for reasons to be recorded in writing, that the judgment debtor has the means to pay, but refuses to pay or neglects to pay the same. This statutory safeguard is the mechanism through which the law complies with Article 11 of the International Covenant on Civil and Political Rights, shortly known as ICCPR, an instrument that prohibits imprisonment merely on the ground of inability to fulfill a contractual obligations. In the case of Charles Luther, Kasamani versus Concord Insurance, the 2018, the court, Judge Muita, does for us. Even under Section 38 and 40 of the Civil Procedure Act, no one should be committed to civil jail because of his or her inability to pay. In the case of an application for committal, the determining factor is always the ability to pay. Inability should not be taken to mean that the judgment debtor has completely no means of settling the decree, even if he was given, he was given how much time to do so. He has completely no means of paying. He is simply unable and cannot pay. In that regard, therefore, where a party goes through a legal process and obtains a decree from a competent court, she has a right that has crystallized in his favor, and that right is recognized in law. It can only be realized through execution, including committal to civil jail, which is a non-legal process for enforcing that right. Such a right should not easily be defeated because of a judgment debtor who is unable to pay cannot be committed to civil jail, and nothing can be done without him. That will be a contradiction in the enforcement of rights, where one right would be deemed to be superior to another. The law should be read as only protecting those who cannot genuinely pay and not otherwise. Committal is a coercive process targeting a contumacious debtor, not a penalty for poverty. In the circumstances of the Small Claims Court, there are processes that are set out in Section 37, which when complied with, they end up with the application of Section 40 of the Act and not otherwise. In view of the foregoing, we are of the view and so on that the Rule 25 of the rules is in breach of Article 24, subsection 2A, B, and C of the Constitution of Kenya, for incorporating the provisions for arrest and committal to civil jail under the Civil Procedure Act. It is therefore unconstitutional and that requires Section 37, 39, and 40 of the Act as read with Article 94, subsection 6 of the Constitution of Kenya. We note that the petitioner, in petition number 10 of 2024, prayed for damages for the arrest and the incarceration. Those actions were undertaken on the basis that the provision of the Civil Procedure Act as incorporated by Rule 25 of the Act were applicable. We have found that the arrest and the committal under the Civil Procedure Act in itself is not unconstitutional or unlawful. The proceedings that culminated in the petitioner being committed were not produced before us. We are not told whether there was any notice to show cause issued and what transpired thereto. Had the petitioner attended the notice to show cause proceedings and proved his inability to pay, we are confident that he will not have been committed to civil jail. The outcome is that the petition has consolidated his partial successive petition number 008 of 24 is without merit and dismissed, while petition number 10 of 2024 is partially successive.
We are alive some difficulties. There are so many litigants who have their cases for claims for personal injuries in RTA that are pending in the Small Claims Court throughout this country. They must have filed them before the issue of jurisdiction was determined. As we have already found, a casual reading of Section 12, subsection 1 of the Act do not have disclosed that such claims were never intended for that court. In the premises, we must guard against such litigants suffering any prejudice in the interest of justice. Further, we should not make orders that may prejudice the cases already pending in those courts, having in mind that even costs, albeit minimal, have been incurred. We must be alive to the dictates of Article 48 of the Constitution. Accordingly, we dismiss petition number 008 of 2024 and partially allow petition number E010 of 2024 as stated above and make the following orders. We declare and hereby issue a declaration that claims for personal injuries arising out of road traffic accident are excluded from Section 12, subsection 1D of the Small Claims Court Act. Accordingly, the Small Claims Court has no jurisdiction to entertain such claims forthwith. 2. We hereby declare and issue a declaration that Section 34 and 38 of the Small Claims Court Act and Rules 18 and 23 sub-rule 3 of the rules, insofar as they relate to small claims under the Act, are not in violation of Article 50, sub-article 1 of the Constitution. 3. we declare and issue a declaration that all cases now pending before the Small Claims Court for claims for personal injuries arising out of road traffic accidents be transferred and are deemed transferred to the magistrate court with jurisdiction. D, we declare and hereby issues a declaration that Rule 25 of the Small Claims Rule, Court Rules, is in breach of Articles 24, Sub-Article 2A, B, and C of the Constitution of Kenya for incorporating the provisions for arrest and committal to civil jail under the Civil Procedure Act. It is therefore unconstitutional and ultra-vires sections 37, 39, and 40 of the Act as read together with Article 94, Sub-Article 6 of the Constitution. E, the claim for damages in petition number E010 of 2024 is hereby declined. In terms of costs, we declare that this being a public interest litigation, parties shall bear own costs.
My Lord, we are obliged with sound reasoning judgment. Thank you so much, my Lord.
On behalf of the respondents and my colleague counsels who are attending the teams, may I say thank you to the bench for the wisdom and the time you have spent on this matter. I believe one of the judges sitting before us today have got serious engagements, presiding, principal judge, and thank you so much for the industry. Our request will be for a copy of the judgment of the court so that we can take further instructions from our clients. But thank you so much for the court. Thank you.
Thank you.
When the court send to the portal, can the court be pending matters?
Yes. Thank you very much, Counsel, who have been involved in this matter. This is a very important matter for the public, and I think the orders which we have made today are far-reaching, and people have been waiting for them. We realize that they are going to cause a lot of movements, and therefore we will be able to make a concise statement on the orders that we have issued for purposes of clarity. I'll direct the Registrar of the High Court to issue a summary of the judgment that we have made. Thank you, Counsel, for the time you have spent in this matter. Some impact to the country as such is normally very, very, very great. And therefore, I take this opportunity to thank the Council who have been involved in this matter for coming out and doing justice to the Republic of Kenya in this matter.
Thank you so much, Madam.